pedagogy and evaluation that is relating to 20 marks. Well, my learned friend has rightly said that, rightly submitted before your lordships. If examination is, since they have committed a mistake by not printing the question paper in both in English and Hindi, if a face examination is held for only pedagogy and evaluation, we have no objection. Now what they say? To be held for whom? For all. For all. For all. All in for all.
And though we have issued the notice with respect to the
exercise their option,
but if the lordship will get opinion,
but their intention is that for the entire examination, that is for 150 marks, re-examination should be made. But so far as 130 marks is concerned, there is no violation, there is no infringement, there is no mistake committed by the commission.
Both are segregated.
Your lordship may kindly see the syllabus. Your lordship may kindly see the syllabus. Your lordship should be more clear.
Yes, I have seen that.
No, my lord may kindly come to page 39. 39. That my learned friend has given the syllabus. Your lordship may kindly see that. 39. It starts from page 38. My lord may kindly see 39. Syllabus for pedagogy and evaluation, it contains 20 marks. It carries to 20 marks. This is for all subjects. And so far as Hindi contents, my lord, that is at page 53. My lord, may kindly see page 53. Hindi, 130 marks for Hindi contents. There was no mistake so far as Hindi contents is concerned. So therefore the key answer sheet was published in respect of Hindi contents, that is relating to 130 marks. Since there was dispute relating to 20 marks for evaluation, that pedagogy and evaluation, well, that result was not published. That key answer sheet was not published. And what they are attempting to, they say that for the entire, for 150 marks, let the examination be held. Although they have participated in the selection process.
That need not be.
Yes.
Most it can be in respect of 20 marks.
20 marks.
Is your submission?
Yes. Then we have no grievance.
My lord, for all.
Yes, for all.
My lord, my short reply. That's your contention also.
Yes.
Only without repeating what I have already submitted. May I be permitted before counsel for the petitioner will make a submission? Only one submission. It's a question of prejudice, madam.
What prejudice is caused to them by it's in your contention?
Yes, madam. As I have already...
Did you know, when you wrote the examination, did you know that the preliminary examination is not held? My lord, knew that.
Preliminary examination is not held, we knew, because when the preliminary examination will be held, that was beset with a condition fixed in the advertisement itself.
Yes, sir. I understood.
Which is?
I want to just...
Your lordship, my lord, yesterday your lordship posed that question, my lord, my answer, my lord, I am just reiterating, my lord. My lord, the preliminary examination for others were held in the month of February. The decision was taken not to hold in respect of us. Immediately, the present petitioner made an application under RTI to know how many candidates were there, how many valid candidatures were there as against the post of Hindi teacher. To that, they replied in the month of March that this information will not be provided till the examination process is completed, and the written examination was conducted in the month of May. And my lord, your lords may kindly see, since nobody was aware how much is the total number of valid applications, question of challenging their decision was wrong. My lord, that contention was completely misconceived. The reason being, unless we knew that these number of valid applications were 5 times the number of posts, question of this challenge could not have been made. So that the information came to us only when they filed an affidavit before lordships in this first case saying that there were 4493 the total valid applications as against 711. Now, my lord, one more thing, my lord.
No, you are not answering my point at all. You are jumping.
We didn't knew.
Why you did not?
Cancellation of preliminary examination was knowledge.
Not being asked.
Yes, my lord. Cancellation was within our knowledge. This ground.
Learned counsel from the petitioner.
Notice was issued on 12/2.
Yes, that is what we are.
Petitioners knew about dispensing with the preliminary examinations. However, he adds that his clients had applied
Annex 4.
RTI
Annex 4 running page 77.
and for another 4 on
On 5/3/2025,
5/3/2025
Commission intimated.
when you had applied
Well, application is 17/2.
on 17 to
12/2, the notice was published.
17 to 2025. The key answers having been
Key answers now. How many valid applications were received in Hindi teacher post? Because they decided not to hold the examination. Preliminary.
You could have challenged this.
Just a minute.
You could have challenged.
Just a minute, sir. Well, on 12/2, they published the notice.
we should never yes, we should silent the
Why is saying his reaction?
lawyers how they used to do.
May I kindly see.
Yeah.
On 12/2, the notice was published that no preliminary examination will be conducted for the Hindi teacher post. Advertisement said where there is 5 times the number of
You have said that and we all know that.
you know. So naturally, we were giving the impression as if there are not 5 times the number of the valid applications to the number of vacancy. To know us,
You came to know it only subsequently.
well,
That's your case.
yes, when we applied to get that information through RTI, they say we will not provide.
Counsel submits that if clients were under the impression that the decision to dispense with the preliminary examination was taken because of the ratio being
Yes,
below the prescribed limit.
yes.
However,
We applied for RTI
subsequently they have applied under RTI
on 17/2, 5 days after only.
into
Only 5 days after the notice.
5 days after
The notice was published not to hold the preliminary examination.
the notice dated
12/2
12/2/2025
was published.
dispensing with the holding of preliminary examination was issued.
Yes, to which they replied on 5/3.
The commission replied on 5/3/2025 that they would not
Disclose this information till the entire process is over.
till after the recruitment.
Entire recruitment process is over. Completion of the recruitment process. That is what the language used in page 77.
Therefore, the contention that the petitioners participated in the examination, the recruitment process,
Which was held on 15/5/2025.
5/2025. Come on. We cannot go against the petitioners in the case. That's your contention.
Yes, ma'am. And your lords may kindly come to one reply to them. My lord, with regard to para 14 of the counter affidavit,
One more thing. With your lordship's permission, before giving a reply to my submission, my lord, may I add one more sentence, my lord, because I took a liberty.
Yes, then you will reply that.
My lord, my submission, my lord, with respect to that prejudice.
One thing I should appreciate, though they are disturbed, you are not disturbed at all. You are very, very firm in your stand. This is our stand. I appreciate that. You don't get perturbed at all. Very smilingly you argue, even if they raise their voice.
So
Anyway, that's
my lord,
appreciated.
my submission, my lord. The figures are before your lordship, as it is already indicated. So it's a question of preliminary examination to shortlist. So in that case, my lord, the maximum probability for the petitioner, had there been a preliminary examination, my lord, that he could have been succeeded and he could have been recommended for the examination, my lord. In this case, my lord, he has not been prejudiced. He has also been allowed to participate.
No, what he says.
My lord, I'm conscious, my lord. I'm just coming to that. Sorry, my lord, because I interpreted the passages words. My submission, my lord, that some other persons also, they came into picture.
Yes.
At the time of competition, my lord, in the main examination. But now, at this particular stage, sir, it is to be weighed by your lordship that the difficulty for the commission vis-a-vis the petitioner, whether he has been prejudiced, and the difficulty of the commission, my lord, in respect of all the categories. For each category, my lord, because we had to recommend 1:5, we did not have the persons. My limited submission, in addition to my submission,
And also there are two petitioners.
My lord, I have.
so a balance is to be taken into consideration.
Yes.
Between the two.
My lord,
Because he is a person who has not been disallowed to participate.
Anyway, he is permitted to
He has
participate.
been permitted to, along with others.
Yes,
Along with others.
because of your mistake, I am made to swim with many other competitors.
Exactly.
Which otherwise I would have not been called upon to do.
But in this particular case, my lord, our submission, it is not a mistake because the figure says that there were no 5 types of the persons in the different categories, and there cannot be, as I have already stated, my lord, it is a amount to repetition, that it cannot be with respect to a particular SCBC category, a preliminary examination can be held. My lord, it is on the basis of the facts and figures, my lord, that it is just by a process, my lord, that he is a person, he is belonging to SCBC category, and the category number of the SCBC candidates are more than 5 times. But in respect of the other categories, it is not there.
And there are four petitioners.
The senior panel considered in this election submits, when Bingley submits, that a report should look into not only the infraction of the norms may be enacted in the rules or in the recruitment notification, but the actual prejudice suffered by the candidate who was permitted to participate in the proceedings in a wholesale basis. Even otherwise, individual prejudice, as between individual prejudice and prejudice to the public interest, which the commission advocates, the later should be kept in view. He adds that no prejudice whatsoever is caused to petition at all. Merely because the zone of consideration arguably has not been reduced by adopting a preliminary examination. That's your stance.
My lord, my reply, my lord. Prejudice has been caused, and how it has been caused, I will now demonstrate before lordship. Your lords may kindly see para 14 of their first counter reply. There they have given a category-wise breakup of the candidates to justify their decision. Your lords may kindly mark. I am confined to Hindi teacher. Since we are concerned with Hindi teacher, we are not concerned with other category. Your lords may kindly see yours, SCBC, SC and ST. And the total number of advertised vacancies you are seeing, number of valid applications you are seeing. Your lordship is seeing, my lord. Now, my lord, your lordship may kindly see, kindly come to this observation of the Honorable Apex Court in para 4 in the constitutional bench judgment of R.K. Saural. Para 4 I have underlined, your lords may kindly mark. And then kindly see whether this affidavit is correct in law or it is misconceived. Your lords may kindly see this paragraph. Because the entire UR post is available even for a ST candidate to be considered, SC candidate to be considered. You cannot bring it like this. Thereby you are compartmentalizing reservation, which is not permissible. A UR category candidate cannot be considered against the reserve category post. But reserve category candidates can very well be considered. So while calculating it, how can you compartmentalize this same and decide whether it is 5 times or not?
Sabharwal, why that R.K. Sabharwal?
Yes, R.K. Sabharwal.
How that comes to be the
My lord, here, my lord, your lordship,
R.K. Sabharwal says,
yes.
in respect of unreserved category, reserved candidate can compete. In respect of reserved category, unreserved candidate cannot compete.
Now, your lordship, kindly come to this table. Para 14. In order to justify this, they say less than 5 times